Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Florida versus Soto-Escalera. We are into day 4. This is the guilt phase of a DP case. They are expecting to rest today with closing arguments either coming this afternoon or Friday morning, of which we will be in verdict watch shortly after that. The defense and the prosecution both expect to be not spending more than an hour or an hour and a half even. When the judge said, I'll give you an hour, hour and a half, the defense says, we're in trouble if we need an hour and a half. So, they are expecting. So that being said, guilt phase, judge wants it done Friday, which is tomorrow. And then we will go into the penalty phase if he's found guilty. Now, from what we heard yesterday, it's almost a foregone conclusion. I hate to say that, but boy, that was pretty. Yesterday's testimony, which basically was the translator reading parts of Jose's talking with Eric while he was driving around his route on his truck, on his garbage truck, and there were some pretty damning statements that he said. If you guys don't remember it, or you weren't, I'm sorry, if you weren't here with us, I'll read you through a few because we have a few minutes here. They start around quarter till, so we have a few minutes here. We can review what happened yesterday. But actually, let's see who's coming in. Barry says people tend to tell on themselves. Fur Baby's mom, that was shocking. Sparkling Princess, good morning to you. Pammy, good to see you. Joanne Jedi Platypus, Sherry M. and Shirley Roth. Green-Eyed Cat, Jennifer King, Terry H. Did they have a verdict with Sunny Bell? Yes. Not here yet. We don't have a verdict yet. Oh, you guys are talking about that verdict came shocked yesterday. Okay, yeah, you guys were talking about Sunny Bells. Bice, good to see you. Amanda, thank you for joining us. I love that music. It's kind of haunting. Yes. Gordon says bluesy intro. That was kind of the vibe Aaron was going for, was just kind of a swampy, bluesy, because that's where Tania was found like on a back road. It was very desolate. So we were trying to go for a haunting, swampy, bluesy vibe. Iowa backyard, it's foggy morning here at the acreage. Yeah, we woke up to a weather alert that it was foggy. But it's clear blue right now and sunny. Mama C, good morning to you. Fanny Pack, good to see you. Thank you for joining us. All right, let's pull through. Let me go through. So yesterday's testimony, there were let's see, there were three new witnesses and one recall. So the recall was Detective Chris Newman. So we had Catherine Scott, who was the neighbor of Tania, and she had a camera, and there was a truck driving by. Now that surveillance I thought was kind of hard to see. I mean, I did see it. Thank you, Iowa. Member for 4 months. Awesome. Thank you so much. Hit the like because Squeegee of Justice deserves all the love. Thank you for that. Joanne, the music is very fitting. Thank you. Hey, Woke, good to see you. Thank you for joining us. Same with the McCormick family. Thank you guys for joining us. So the truck that was shown on the first video, I thought was kind of hard to see in my opinion. But then we had recall of Chris Newman. Then we had Norma, and that truck drove by at 8:28. So that kind of makes sense that Tania's mom said she left around 8:15, and that's the last she saw of her. So that makes sense that she got picked up. She got picked up by Jose. And then there was I didn't catch her first name. Carino, I believe, was her last name. I even had trouble catching her last name because she spelled it, and I think that's what her name was. Regardless, apologies for not getting your name proper, but she was a neighbor to Jose, and that video, that was pretty clear. You could definitely see a truck, and that was at 11, I think, 11 and change. I forget the exact. Let me see if I can, let me find out what her, well, of course, I didn't write it down. All right, I didn't write the time down, but I think it was like 11, maybe 11:08, 11, something like that. So that just shows that on the day that Tania went missing, he was in her neighborhood at 8:28-ish, and then he was back in his neighborhood at 11. And we also have his cell phone data, which was pretty, I thought, pretty damning. And then, of course, yesterday's testimony with Norma Campos. So there's going to be two translators. Norma was the first one. Then we have a Rose Rosario. She was testifying in Broward. And if you guys remember from yesterday, Broward is there's 4 counties down. So you got St. Lucie and then Martin County. So St. Lucie is Fort Pierce. That's where this is taking place. So you got St. Lucie, then Martin, then Palm Beach, which of course is West Palm. You have Broward, which is Fort Lauderdale. So she was testifying 3 counties down. So Martin, West Palm, and then Broward. So she was testifying 3 counties away. So she's going to be testifying today in the morning, and then that's it. I think the state is resting. They're ahead of schedule, as they said. Defense probably won't put on a case. Doesn't sound like they will. So yesterday, Miss Campos was reading with a gentleman. So he was reading Jose's parts, and then Norma was reading Eric's parts. So there was definitely some seriously like, wow, why are you saying these kind of things? So some of the things were, let's see, no one knows anything because of what I'm wearing. If they go to my house, I'll throw them away or wash them with Clorox. If I do it quietly, I'll pull over and take a break, and then you'll know. It's if I use my truck, I'll cover my plates. I'll blow her brains out. I need your help. I mean, just crazy. She disappears for a few days. I'll take her phone and throw it away or burn it. I was thinking about taking her somewhere on my route. I have everything planned out. I'll have her drive. I'll sit in the back like we're going to do something. I'll hit her and then dump her. I mean, just stuff that. How are they going to get around this? Bullets leave a mark. That doesn't leave a trace. Let's see. I've got everything planned. I'll go home, get some tools, tell my wife I have to work. What do you think about choking her? It's better than a blow. I mean, just stuff that you just can't. I've got to strangle. I can't do it inside my truck. I've got to strangle. This, calls her a bad word. They'll blame her boyfriend because they're always arguing. The blow, that's it. Everything ends. And then Eric as well. Like we were questioning yesterday about Eric, why isn't he indicted? He very well may be. I don't know. But he's like, I would have done it myself if I didn't have a daughter. I don't want that to happen to her. Let's see what else. Right here, it gets done quickly. I already found a spot here. That's not going to be anything here to put her inside. You don't want anyone to find her, but that's a good spot. I'll drop her off right here. She won't have time to use her phone. I'll bring my tools. No one will hear her if she screams. The thing is, no one will hear her scream. I mean, just not looking good for Jose right now, based on this. And then we also have his DNA matching, or the paternity test matching. He's 99.9, 10 zeros. So 99.999%, 999%. I sound like Chevy Chase. No. Yeah, so 99.9999999% that he is the father. So we've got cell phone data putting him with her. Both their phones are tracking north. We've got 99.999% that he's the father. We've got this conversation that he had inside of his truck while he's driving around. And then the defense, the cross, was missing a lot of information from the farther away person, missing parts of both conversation, mostly not audible. So the defense basically was, she didn't author the draft, but she reviewed it. The final draft is certified by the FBI and the court. How do you describe the massive discrepancy? I don't think the defense really got anything. I don't think they won any points on their cross, to be quite honest. So, bot needs to be recalibrated. Will Wendy be arrested soon? I will say no. Hush it, bot. Zip, 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 zip. Yep, Jennifer threatening to do it. This was the day of. This was August 23rd. This was August 23rd that conversation happened. So it was the day of. All right, here, I think, let me get us over here. Hey, Mike. Good to see you. Agent 333, I missed a lot of the trial. Who recorded the conversation? It was from the truck he was driving. Hold on, let me get myself here. He's driving a truck, and the truck has four cameras. One of them is in the cab, so he's a garbage truck, right? He drives for Waste Pro. So he and Eric, he's a driver. Eric is just, I guess, the person who gets out and gets the garbage, the recyclables, all that stuff. So he's driving. Eric's in the passenger seat. There's a camera in the cab. I think it's over by the driver. I'm not sure, but I think it's there. And then there's three others, but one faces what the driver sees. One is what the driver sees in the back, the rearview mirror, and then one is actually in the back. So the only one that actually picked up, I think, the conversation was in the cab. So this was actually his work. His work truck. So. He worked for how long, and he didn't know there was a camera? I know, right, Shirley? It's a good question. I don't know how long he actually worked there, but that is a really good question. Like, what are you doing? Just, what are you doing? Hey, Angelique. Thank you for joining us. Good to see you. Bot is off his meds. Totally. Let's see. I think that's what might... Okay, what am I confirming? Let's see, from Sherry. Sherry is asking a question. Sherry, what was your question? So how was she unalive? Did he use the bullet holder or a cutter? She was sliced twice here, 7 inches from front to back, almost through. You could see her spinal cord. and she had a blow, a 3-inch blow to her skull that fractured her skull. So, sharp, presumably a knife, but a sharp object wound from basically her jugular all the way like 7 inches, right? 7 inches is, well, 7 inches is pretty long. That's 7 inches, right? So so that's 7 inches from here to here, 7 inches. So, it's a pretty long cut. And then there's I think it was a 3-inch blow or 3.5 blow on the top of her head that basically split her skull. So, Green-Eyed Cat. Our delivery trucks record everything the drivers know. I think he just was thinking about it. I think he wasn't thinking about it. Yeah. Is Daisy with us? There's Daisy. Good morning, Daisy Jane. Thank you for joining us. Mike, we need a new bot. I would like to submit my application. Quackers the bot. G. Stewie brutal. He should never get it. Well, this is a DP case. This is a D penalty case. So, hey, Deviant, you going to be sick? Little Lulu, good morning to you. Fur Baby's mom. After the jury listened to the audio, I think it will be a quick verdict. Yeah, the full thickness of a neck, basically. And it went through the Emmy, the medical examiner said you could see her spine, basically. So he sliced her through. Sliced her through. Kathy, good to see you. No, state has at least one more witness. I think just one more. It's the other translator. So there's 2 FBI translators, but they should be resting today with closing arguments. The judge said either today or even Friday morning. So it'll be really weird if they rest by like noon and then they send the jury home, because they did that yesterday too. They sent them home at like 2, I think, or something. So, so the state will rest today. Defense does not sound like they're putting on a case. And then we'll get to closing arguments possibly today, then tomorrow morning. And, here we got a seal. Let's see, I can put myself over here. Whoop. Yeah, Richard, how's your ear? Any better? Did you get that sorted out? Nothing wrong or nothing worse than having pain in your ear. Hey, Mary, good to see you. Thank you for joining us. Richard, Eric's going to get, I don't know. Well, he's in Connecticut and he's in custody, so who knows what's going on with him, because we found that through different bits and pieces, that he's in Connecticut and he's in custody. So I don't know what he did, why he's there. I mean, he's an accomplice in my opinion. So he's literally talking about it and helping. He's supposed to throw something away. He's supposed to drive to Miami, throw something away. Mary, it will be one of the quickest verdicts we've ever seen. He's cooked. Yeah, I think so. I would be shocked. I'd be shocked if they go more than 2 hours, but you never know. We'll have to see what the jury. It is a D penalty case, so it is DP. So they're qualified. They had to say during jury instructions, we are okay with putting somebody, so. Oh, Sherry, okay, 10 years for kidnapping. Okay. Good, thank you for that, Sherry. Appreciate that. Kalia, good to see you. Good morning to you. That's a Bonnie seal. It's very gold, isn't it? Very gold. Richard, a little better, but the tinnitus is more. That stinks. Tony, good morning. Happy to catch your live here. Awesome. Thank you. Thank you for joining us. Cindy, Frankie Avalon is 85. Wow. Man, 85. Whew. All these people that we grew up with are just. Just Jen, crazy how calm he acted when he was with the police. I know, right? Kathleen, good morning to you. Jennifer King saying good morning. Thank you guys for joining us. Sherry, I wonder how many objections the defense will have. Yeah. G. Stewie, I agree on Eric. It does seem like the defense, well, they're fighting for his life. I mean, basically, honestly, they are literally fighting for his life. Katrina, number 49. Thank you. Oh, you know what? I have to follow. I have to do that as well. Oh, no, I just did that on. No, I don't want to do it there. I just did it on another stream. Don't want to like them. And don't worry, it's not a content creator. I would like a content creator. I'm not going to like another large channels. If you know what I mean. And actually, I tried to like it and I couldn't, so I guess I have to be subscribed or something. I don't know. All right, anyway. Mandy, welcome to Rabbit Ears. Daisy, what was the point of the defense attorney arguing gestation period of the baby? Was it yesterday? I do remember that. Yeah, it was either 38 weeks is what the Emmy said, but then the OB came in, the high-risk OB came in, and he said 31. So 31, 38. I mean, yeah, come on, people. I mean, just totally splitting hairs there. Woke, Jimi Hendrix. Yes, Jimi Hendrix birthday today. Northwest. You pounding some coffee there? Thank you for joining us, Northwest. Always good to see you in our chat. Kelia says, if there are cameras on the truck for collisions, I'm not sure I'd realize they were recording conversations. Right? Oh, is Aussie with us? There you are. Aussie Gardner, good morning to you. Thank you for joining us. Hey, Nicola, good to see you. Mike's got to run into a class. National Cheeseburger Day. Cheeseburger. No Coke, Pepsi. Cheeseburger. Disney Adult. Hopefully that garbage truck company will vet their employees a tad better after this. But he didn't. He didn't commit a crime before, so that's kind of, you know what I'm saying? That's like, how do you know somebody's going to do that? That's a tough one, because how do you know somebody's going to do that? Virtuous, good morning to those I didn't see earlier. Let's see, anybody else I'm missing? Ed, 3138, who do we appreciate? I know, poor baby, I think Josiah, I think was it? Is that what they were calling him? They had a name for him. Baby Josiah. Josiah or Josiah? Yeah, baby Josiah, I guess is what they were going with. Or baby boy Wise, baby Josiah. Yeah, that's so sad. So sad. So, let's see. Baby could have survived either way. Yeah, absolutely. That's why they've got him up for 2. That's why they have him up for the D penalty, because it was heinous and it has to meet certain criteria, and this is one of those criteria that it meets. Nicholas waving. Yeah, he had no criminal, as Northwest said. Defendant had no criminal history, so you could vet him all you want, and nothing would have come back, as far as we know. So, Jersey Tomato, Jimmy is a legend, brilliant. Yep. Nothing wrong with Mr. Hendricks. Bice, defendant did his very best acting during the interview, wanted to scream every time he said, "That's crazy." Yeah, that is crazy. That's crazy. I know, right? Sparkling Princess, her mom said they were getting her C-section all scheduled. Yeah, the next week she was going to go in to get scheduling for the C-section. Would make sense. She was more at 38 doing that and not 31. She was just getting scheduled. Like she wasn't going in to get the C-section. She was going in to get scheduled for the C-section. So they may have scheduled it out, a month. I don't know. I don't know how, what the deal is with that. But Kathy saying good morning to everyone. Aussie, go grab yourself a cuppa. Baby was 5.22 pounds. Let's see. They did tell us what the, let's see. 5.22 pounds and 28 inches. So, by all counts, baby was very healthy, no issues, so. Kelly says it's still, even if he was 20 weeks. Yeah, I mean, and his own son. Yep. And he knew. Well, she was saying it was his, and he's, he didn't want to, I guess he didn't want to accept it or whatever.
Jurors are all in the back, I'm told, all of our jurors. Okay. Any issues to address before we get started with the evidence? From the state? Any issues to address before we get started with the jury? No? Y'all ready for the jury?
Yes, sir.
All right, let's bring the jury and we'll get started. Okay. We'll go off the record until we're ready for them to come in.
All right. Lawrence Merman. B.B. King would have been 100 on the 16th. Yep, 100, wow. Gordon, you're just making us feel older and older. with facts like that, it's just like, No, they haven't even brought the jury in yet, Barry. They got to bring the jury in still. So we're waiting on the jury. Cindy says an expert last night said Josiah could have definitely survived. Yeah, 100%. Healthy baby and all counts very healthy. If someone had found her sooner, baby had a good chance of surviving. I think they said, the Emmys said that once the mom's heart stops beating, it's pretty quick. It's not, right? You guys may know better than I, but I'm pretty sure the Emmys said, let me just see. Baby would have died within a matter of minutes after the mother dies. So, yeah, I mean, I think if it had been maybe within 5 minutes, maybe, but once the mom's heart stops beating, and according to the Emmy, my notes are, baby would have died within a matter of minutes after mom. The head injuries could have occurred before the neck injuries. The neck wound on its own would have caused her passing if no immediate help. It was 19 centimeters, so 7.5 inches and a depth of 1.5 to 1.25 inch. It was from the neck, from the front to the back, and there were two wounds that merged into one. So then there was a smaller one by her left clavicle, 2 centimeters, and a 0.5 centimeter in depth, and then the blow to her head was 3.5 inches. That would have rendered her unconscious. It could have caused her to pass. So we don't know what the weapon was, Jennifer. blunt force and sharp force. We're not sure what weapons were used because none were recovered. So, hey, Trixie, thank you for joining us. Bice, yes, baby passed in minutes, no oxygen.
All right. Good morning once again, ladies and gentlemen of the jury. As you're aware, it's my custom at the beginning of every court session to re-advise you the most important principle of a fair trial is that you, the jury, judge the case only on the official evidence presented in court and nothing else. So continue not to talk about the case or the issues or the people involved in the case with anyone, including your fellow jurors. Don't do any research in any form whatsoever, and avoid all media coverage of the case in any form whatsoever. We continue with the state's case, and the state may call its next witness.
State will recall Elizabeth Bedola.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Hand over to the witness stand.
And you may inquire of the witness.
Good morning.
Good morning.
If you could just state your full name and spell your last name.
It's Elizabeth Bedola, Bedolla.
Okay, and you are Tanya's mother, correct?
That's correct.
I want to show you what's been marked for identification. State's Exhibit 146. Do you recognize this?
Yes.
How do you recognize that photograph?
She's my daughter.
Okay, and is that your daughter from when she was alive?
Yeah.
This time the state would move into evidence what's been marked for identification as State's Exhibit 146.
No objection.
That item will come into evidence without objection.
And at this time the state will just publish what is marked or entered now as State's Exhibit 146. Thank you, ma'am. I don't have any other questions.
Any questions from the defense?
No, Your Honor.
Thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. People say before I call Rose Rosario.
If you can raise your right hand and face the clerk.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, please? Thank you.
Over that way to witness stand.
And you may inquire of the witness.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, Rose Rosario, Rosario.
Okay. And Ms. Rosario, what do you do for a living?
I am a interpreter, translator, transcriber, practitioner.
Okay. Go ahead and give the jury a thumbnail sketch of your education, your training, and your experience, please.
Yes, good morning. I was trained by the Uruguayan Air Force. I was a diplomat interpreter, translator, and transcriber. Later, I started working in 2004 with homicide units for the 19th Circuit Court, and then with the 17th Circuit Court, doing transcriptions and translation.
And where is the 17th Circuit?
17th Circuit is in Broward,
Broward County?
the Broward courts, yes.
Okay. I didn't mean to cut you off. Go ahead.
No problem. I got my certification in 2012 as a transcriber, translator, practitioner. And I've been working the field close to 21 years.
Okay. And just some background questions. Where did you grow up?
I grew up, I was born in Cuba. I came when I was in the second grade, so I was raised in Hialeah, Miami area.
Okay. And were you raised in a home where Spanish was the primary language?
Yes.
Okay.
Yes, it was.
And did you learn English? Obviously, you know English, right?
Mhm.
Okay. And how well do you know Spanish? It's obvious, but how well do you know Spanish?
Oh, very well. My parents made sure that the Spanish language was not lost when we started school. So we had to take Spanish lessons all the way from elementary to high school.
Okay. And did your parents, did they only speak Spanish, or were they able to learn English as well?
No, they learned English. They were nurses, so they
Okay.
learned English.
Okay, good. And did you have any formal education in Spanish?
No, not formally, just the one that you take in school, advanced Spanish. And Spanish was always spoken in the at home.
Okay.
And then I married into a Spanish home also.
Okay. And you said that you worked for the Uruguayan Air Force?
Yes.
Okay, go ahead and describe that experience for the jury.
Okay, I worked as a diplomat, interpreter, translator, and transcriber. So,
having difficulty hearing the witness? If you could keep your voice up.
oh, I'm sorry. Okay, at the Uruguayan Air Force, I was trained as a diplomat, interpreter. I was the interpreter for the assistant air attaché. So we did all the interpreting for all the foreigners, vendors that came into the office. I translated everything that was done in that office was received in Spanish and had to be translated into English. And then with the vendors, it had to be translated back from the English into the Spanish to give back the responses to the Uruguayan Air Force. It was your purchasing office.
Okay. And you did that for how many years?
5 years.
40 hours a week?
Yes.
Okay. And from that point forward, where did you go and what did you do as it relates to to Spanish and Spanish translation and interpretation?
I started, in 2004. I went back, I got away from the interpreting field for a little bit. I did real estate. Then in 2004, I got back again into the interpreting field, and I started working with 19th Circuit Court, doing the transcribing for jail calls, confessions, everything pertaining to homicide cases.
Okay. And go ahead and you mentioned that you had obtained a certification.
Yes.
Can you explain that to the jury, please?
Yes. In 2012, I got a professional certification for the transcribing, it's called transcribing translator practitioner. And by that time, I already had acquired about 5,000 hours of transcribing and translating for the Uruguayan Air Force. From 2008 to the present, I have acquired 4,500 hours in homicide cases for translating and transcribing.
Okay. And to be clear, the primary language of Uruguay is Spanish.
Yes.
Okay. And describe the transcription process for the jury. Tell the jury about that.
Okay. First, we get the sound file or the audio files. We listen to it. You have to listen to it several times before you start transcribing so that you can get familiar with the voice, the speech pattern, the volume. Once you hear it a couple of times, then you start the transcribing process. The transcribing process is done before you start the translating part. Once you have that, if you take a look at the format, You have a column that's in Spanish and a column that's in English. So once all the transcription is done, it gets proofed. We proof it to make sure that we've got everything down that was transcribed. After that portion is done, then we start with the translating part.
Okay. And let me ask you this. Is there a difference between translation on one hand versus interpretation on the other?
Yes.
Okay.
Yes.
Explain that distinction to the jury,
Okay.
please.
So the interpreters interpret orally. The translators, we do documentation, word documentation. Everything that's in the written form, it's a translator. Versus the interpreter, which does oral.
Okay, so as a practical matter, is there a big distinction between the two? Describe the distinction in practical terms to the jury.
Yes, there's a big distinction. It's two different professions. Sometimes there are translators that also do interpreting, and the same way interpreters that do translator, but it's a different field. Interpreters go in and out. They interpret on the fly. Translators have more time to work with the document. We're able to research and go over and over again the document or the files that we're working with.
Okay, so and again, to put it in practical terms, let's say I were to call a witness who only spoke Spanish. Would you be the person to interpret that to the jury, or would you not do that?
No, that would be an interpreter.
Okay, so to be clear, what you're doing is translation. You're not doing interpreting.
Correct.
Okay, thank you. Okay, and were you provided some evidence in this case, the state of Florida versus Jose Soto-Escalera?
We were provided with sound files and videos.
So I'm going to show you what has been marked as State's Exhibit number 169. Do you recognize this?
Yes.
Okay, what is that?
This is the denoised audio video, about 11 hours long.
Okay.
That we worked on.
Is that an external hard drive that contains the audio and video and all the materials you reviewed in
Yes.
order to arrive at your conclusion in this case?
Yes.
Okay, and did you translate the August 24th, 2018 video and audio from a Waste Pro garbage truck?
Yes.
Is that what's on there?
Yes.
Okay,
Yes.
and did you reduce your findings to a written transcript?
Yes.
Okay, and does that transcript reflect what you listened to when you listened to exhibit number 169?
Yes.
Okay, and Your Honor, permission to publish using the same procedure we did yesterday?
You can ask the witness questions about content of sections of the item.
He's referring to having another person come in to read.
Oh, okay,
Yeah.
yeah, but in that form, yes, you may do
Okay.
that, okay.
Okay, we're gonna go get Mr. Blanc. And while we're doing that, tell the jury how many hours that you spent on exhibit number 169 in arriving at your conclusions.
Okay. Like I said, it was an 11-hour video. We spent close to 110 hours, between 110 to 150 hours working on the videos.
Okay, okay. Over a period of how many weeks or months?
About 2 months, 2 to 3 months. Because the way you do this, you can't work on these more than 5 hours. It's too exhausting, so we do sessions of 4 to 5 hours tops.
Okay. And, okay. Here's Blanc. Come on. Do you have a copy of your transcript? You can use mine.
Morning, Your Honor.
Okay, so Ms. Rosario, can you, we'll start off on page 1, and Mr. Belanca will play the role of the individual that can be more audible. Ms. Rosario, you will play the role of the individual that is less audible. Does that make sense? As we described in my office?
Yes.
Okay, so we'll go ahead and start on page 1. Ms. Rosario.
Know what's crazy? All these gloves are,
Throw all that out.
it's garbage.
Inaudible.
Where the hell is the ox tape at?
That's in the bag. Oh Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it. Later. That I would have. Unintelligible.
Well?
You can't be mad at people.
Huh?
You can't be mad at the people.
Yep.
We can throw it in there.
Put on the gloves.
Okay.
Objection, Judge, may we affirm?
Yes. Let me return to line 20. You follow me, Ms. Rosario?
Yes.
Okay, line 20, go ahead and read all of that particular section, please.
Okay. We can throw it in there. Put on the gloves.
Line 21.
Okay. The ones of that black.
Judge,
Okay, we'll go back. Line 20, Mr. Belanca. Go.
We can throw it in there. Put on the gloves.
The ones of that black.
Yeah. Stay with those. Don't let, because they have my prints. Pretend that so that nobody sees you. Sure, it's good. Right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up. We'll do it inside, man. It's best. It would be good with trash. If it don't work out, okay.
Back and forth. Back and forth. Through there. It's coming.
Take it out of the bag. Put on the gloves. Take it out that I'm going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro.
Yeah, ain't nothing outside.
That was incorrect. You need to go back. As far as who speaks the line, correct?
Let's go.
Jury, let me ask you to step back into the jury room for a moment so we can sort this out. We'll be with you momentarily. Please leave your notes in your chairs and do not discuss the case. All right, we'll go off the record as the transcript is being highlighted to avoid the wrong parts being spoken. Go off the record momentarily.
So I guess they're highlighting the appropriate sections of the transcript. So we've already had three sidebars. This is Rose Rosario. This is from August 24th. So this is after. Actually, this is as they found. So August 23rd, 8 o'clock, 8:15 is the last that Tania was seen. She was found at 10:50, so basically 11 o'clock the next morning, the 24th. So now they're talking, they have my prints, use these gloves, so, those have my prints right here, bro. We can throw it out. Can back up, we'll do it inside. Take it out, put on the gloves. Who's going to find a gun there, bro? I don't know, bro. So keep in mind, this is afterwards. This is the day, or I'm sorry, the day of that they found her, but the day after she is gone. She is some 9 o'clock maybe, 9-10 o'clock, something like that. So no. As far as I know, they got divorced was January, and then it was finalized. I think, Joanne, do you have that, or Cindy? Do you guys have that information, or Sherry? I forget. You guys are talking about that. I think it was January. It was filed. Kelly, I can't stop hurling insults at him. Yeah, it's just terrible. Amanda, just terrible. I agree. Richard, this ear thing is so crazy. I started wiping just inside the ear with a wet wipe, and now the swooshing sound is gone. Interesting. Final in June. Okay. So just a few months ago it was finalized. Thank you, Amanda. So to answer your question, Woke, no, he's not. He's not married. He lost his wife anyway. Yeah, they are not married anymore. Now, where is the defense going? Wow, she had to walk all the way around the table. Hellwriter, I know, right? Right, I'm trying to be civil. Well, as they say, everybody deserves a defense. No problem, Oak. No problem. Agent, wow, the truck recording puts nails in his coffin. Poetic justice. And the guy that's reading it, I forget, I didn't catch his name yet again. So he's portraying Jose. So the guy standing up, the guy talking is portraying
The jury is
Jose.
not present.
If you'll notice on page
All parties present.
13, there is an MV3. So we can, I'll defer to counsel. We can skip it or delete it, or we can have Rose Rosario read it.
I think you would just.
I think we could just skip it.
No, I want there's
Yeah,
a
we'll
third
have-
person in the
We'll have Rose
translation,
Rosario read it. Yeah.
but she needs to make certain that it's a different person.
Right, yeah.
So I don't know how you plan to accomplish that, but
You could,
She'll say it.
one of the prosecutors could read that line.
agree with that
Yeah.
Okay, yeah.
methodology.
Before you do, though, before we get started, we'll go back from the beginning, reread the whole thing.
Yeah.
And if you want to just clarify through the witness that at some point there's a third voice, and that will be stated by whoever's going to state that.
Right. Okay.
You're still doing the highlighting? Okay, take your time.
All right, well, we're still highlighting, going through. Hey, Denise. Oh, sorry, Dennis. Geez, sorry. Dennis. Coffee time. Cheryl. Don't get tired as a jury to keep stepping out. Judge needs to go to a dictator school. He's far too democratic. So they're highlighting certain sections. I think because this is a DP case, he's just trying to be really, really careful.
Back on the record, this is for the lawyers, all parties are present. Have I ever told the jury that the transcript will not go back into evidence? I don't believe I have. I think I should,
Yes, sir.
because they're going to ask for it. Just to be sure that this is just being used to assist putting the evidence on. The evidence is the testimony, not the transcript. The transcript will not be available, so they could take notes.
Yes, sir.
Okay, so I will do that as well before you get started.
I'll clarify both transcripts.
What's that?
I will clarify both transcripts for the one yesterday as well as today, if that would be okay.
What do you mean? I'm going to instruct them on that.
No, yeah,
That's
but
what I mean.
we didn't
Neither
tell them
transcript
yesterday.
is
Yeah.
going to go back,
Yeah.
not just this one.
Right,
Yeah.
okay. Still doing the highlighting. Okay.
That's true.
I'll have those 3 lines right down.
I love that, Pammy. That's great. Critical hit. That's awesome. They're going, Sue, has anyone questioned the prosecutor's flood pans? What day are we on? We are on day 4. So they're highlighting the transcript. I don't know why they didn't do this before. There's a third person, I think. There's a third party in this. This is the 24th, don't forget. So this is the day that she is discovered, that Tanya is discovered. So all I know is they're highlighting the transcript, and there's a third party. Why they didn't do this before, I do not know. So, thank you, Pammy. We appreciate you. You are number one. You're number one in the chat right now, Pammy.
Give me 1 second.
Whoop, don't show that jury box. The jury's not there, but don't show that jury box. Small courtroom. Gosh, you could probably fit like maybe 5 people on each side. That is a small courtroom. There's only one bailiff that I can see. Oh, 2 bailiffs. So they're highlighting parts of this transcript. There's a third party in this transcript. Why this wasn't done earlier, I do not know. But that's what they're doing right now. And they're going to go through and reread what they've read already, which is only, a minute or 2, not a big deal there. And this was an 11-hour video, but it took her, she said, 110 to 150 hours. Spent
All right,
over
back
2
on the record, the jury is not present. There was another issue.
Yeah, yes, sir.
State.
If you'll take a look at page 3, and it's line 37. Let me know when you're there. Ms. Rosario? Yes. Can you please explain, if you take a look at page 3, line 37, and just tell the judge what you told me about page 3, line 37.
Okay, so on page 3, the box 37, they stepped out of the truck, so we were not able to see who was the person speaking. I just transcribed the conversation as I heard it without designating anyone because I wasn't able to see who was doing the talk.
From the reading, as we cannot attribute it to what we're now calling the closer participant and the further away participant.
No objection.
All right, so you're both agreeing just not to read that?
Correct. Yes, yes, sir.
Entry 37. Okay, that's fine. Otherwise ready for the jury? They're still doing the highlighting?
Yep,
Okay.
lots of boxes here, sorry.
Cindy, I would say, so what if Cindy's asking, what if blood was only found, what if blood was only found on the driver's side, which it was,
Off the record momentarily.
that would help the defense. The only thing I could think of is then that would be, I don't see how that would help the defense, to be quite honest, because it was hers. They identified that as Tania's blood. So it's I don't see how that would help the defense, you know. And I forgot about that. I forgot about the blood in his truck. There was, like, I think on his seat, the seat belt, the floorboard tested positive for her. So we've got the baby's DNA. He's the dad. You got the cell phone data. You got her blood in his truck, and you've got now 4. You've got this transcript of him talking. So he's got some pretty high mountain to climb there. Awesome Potamus, thank you for joining us, and thank you, let's see, we got some new people coming in, but I wanted to thank John Rodriguez and Aussie Gardner and Joanne Jedi Platypus. Thank you guys for the Trial TV Live gifted memberships. And John, will suspect's ex-wife testify? John, as far as we know, for the prosecution, I see. And thank you again for your $2 donation and support. Appreciate you and that. Very kind of you. No, because this is the last witness as far as we know. And the defense does not sound like they're putting on a case. So as far as we know, this is going to be the last witness, and then they're going to rest. Hey, Seagate, good to see you. Thank you for joining us. Sparkling Princess, yeah. As far as we heard yesterday, this is going to be their last witness. Welcome in all the new folks. Welcome in, welcome in. Kathy is welcoming you in as well. Let's see. Just give me a second here.
Seven. And that was the third person. Okay, so that's what.
No, sorry, Judge, just to be clear for the record.
There's another one that was the third person.
Right, 37 is allegedly, this witness is saying that in 37, the 2 individuals step out of the garbage truck and they cannot determine
Correct.
who the speaker is.
Just off the record, Mr. Richardson said no one's reading MV3, and that's not accurate. The state's going to read MV3
I'm gonna read
on the other
MV3 on
page.
page
Okay.
Yeah, I thought you were talking about the
37.
one that we
No one's reading
that he's
37.
reading.
Correct.
Yeah.
I'll go off the record momentarily. Let's bring the jury in. I'm going to tell them we're going back to the start. I'm going to tell them about the transcripts not being evidence, the evidence being what's said in court, and give them instructions on that to assist them in deciding whether to take notes. All right, ladies and gentlemen of the jury, in the witness and the conduit witness, as I refer to it, reading the evidence, there was some slight mishaps, which is going to cause us to go back to the beginning. You should know the testimony in this regard is going to be much shorter than the one you experienced previously. Also, I wanted to tell you before we get started, too, as I've mentioned, it's up to you to decide whether or not to take notes, but in making your decision, I think you should know this information. With regard to the translation evidence, which is what we're doing here, the evidence is what is being said in court here. The transcripts themselves that the witnesses are using to do that are not evidence pursuant to law and will not be available to you during deliberations. So please be aware of that. You should know, though, too, during deliberations, should you need to, you do have the ability to re-listen to the testimony, to be brought back into the courtroom, and I would replay the testimony to you. You would have to hear the testimony in its entirety unless we were to determine otherwise, but that is the default legal position. So I just tell you that in your decision whether to take notes, and as I mentioned before, disregard what you've heard previously because there are some slight errors in it. We're going to go back, the state's going to go back and restart the testimony in that regard, and you may do so, Mr. Richardson.
Yes, sir, thank you. And Mr. Zari, before we begin, are parts of this also in English that the speakers are using? Are they using a mixture of Spanish and English, or is it completely Spanish?
Sometimes it's in Spanish, sometimes they use what we call Spanglish, which is a word that it's anglicized, or they switch code, which is they speak in a sentence in English and Spanish.
Okay, and a few more questions. Are you familiar with Spanish that's like variations of Spanish, like Puerto Rican?
Yes.
Okay, explain briefly to the jury your experience with Spanish derived from Puerto Rico.
Okay. Although I was raised in a Cuban family, my husband, whom I was married to for 25 years, is Puerto Rican.
Okay. Do you have any trouble or difficulty understanding Puerto Rican?
No.
Or Puerto Rican Spanish?
No,
okay.
the regionalisms, no.
Okay. All right, so now we're going to start again, and we're going to start on page 1.
Mm-hmm.
And we're going to start with line.
Before you do that, can you explain the other part where Mr. Cormier is going to be assisting what's going on there?
Yes, Ms. Rosario, is it your understanding that Mr. Cormier, is there a third participant within this particular item of evidence?
Yes.
Okay, explain that to the jury.
Yes, there's a third participant, which is when they get to the weight station, and the guy that's doing the weights, the scales and all.
just give a very brief explanation of why someone else is speaking. Without,
Without getting into what you saw and what you heard, just why is there a third party there?
Because they get to the news station and
just as far as the voice is heard and why there's a third speaker, just focus on that, not with regard to what's going on in the context.
we designate a voice number for everyone, for every speaker that we hear. So number 3 would be that person.
Number 3, again, is an unknown party.
Correct.
Okay, gotcha. Okay, so we'll go ahead and start.
Okay. Know what's crazy? All these gloves are inaudible.
Throw all that out.
It's garbage.
Inaudible.
Inaudible. Where the hell is the aux tape at?
That's in the bag. Oh Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I should have, I would have. Inaudible.
Well?
You can't be mad at people.
Huh?
You can't be mad at people.
Yep. We can throw it in there. Put on the gloves.
The ones of that
Yeah.
black?
Yeah, stay with those. Don't let, because they have my prints. I'll pretend it nobody so that nobody sees you. Sure, it's good right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up? You know we'll do it inside, man. It's best. It would be good in with trash. If it don't work out, okay.
Back and forth. Back and forth. Through there. It's coming.
Take it out of the bag. Put on the gloves. Take it out that I am going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro. Yeah, ain't nothing outside.
Up to there is good.
Put it on the floor then.
Huh?
Put it on the floor.
If there are many cars, forget it. Go back.
Don't look that way. I'll tell you, inaudible. Ready to come inside?
Here. You don't have any messages or anything like that.
Where?
Of hers. Online.
Threatening her or something like that?
No.
No, none of that.
No. No.
There's none of that.
Inaudible. No. Inaudible.
Let me go see something. I did inaudible things. Good.
I could have done it alone.
Huh?
I could have done it.
You know why I showed my face? So that they don't assume.
Take the right. Where the hell are you going, bro?
When I get home, I have to go check it right there. You know what I need from you? Keep me occupied, so I don't think. I was talking to a policeman friend of mine about things like this. He says it is not proof of anything. It is inaudible standard. That is not
Yeah.
like a revolver that leaves prints.
As soon as I walk in, all she looks at me and she says, inaudible. Somebody else. Inaudible. 6:45, bro. And don't call.
I left at the house 5:05 on top of the fucking pad.
Huh? Telephone call. Hello? Hey?
I have to go to the house. Got to go to my house right now. You hear me? Got to get something. Yeah.
Telephone conversation. I'm on the road. Inaudible. Can't get to. Inaudible. Oh, that's what I'm saying. I'm on the road.
Is she still at the house?
Huh?
At her house?
She's leaving. She told me she would like. Inaudible. Oh, God.
Well, I'll see you at the house because I have 4 cartridges bags on top of the pickup truck there that match the cassettes.
Where are you going to pick it up?
Now, move, dump that, go to the house. Should I tell Mike, inaudible, I'm driving and my wallet I left at home.
Can't be fucking. You can't think too much. You can't be back and forth because that's how you get caught.
That's tough.
You gotta act calmer.
Yeah, the auxiliary port cord. It's there in that bag.
Huh?
The auxiliary, I'm saying, the wire.
I had it there, right there, this part here. You put it in.
Hold on a second.
So this recording, as well as the one yesterday, is coming from his Waste Pro truck. He's a garbage truck driver, and Eric is his passenger helper. So the guy talking is Jose, the female is Eric. So this is from the garbage truck camera inside the cab.
Can you please restate number 72 on page 5?
Yes. I had it here, right here, this part here. You put in the output and this little thing. You just put it, I put it right there and it all stays.
It's rolled up in that little black thing. You'll see it. It's in the top zipper. Where are you at? You're in the wrong place. There, right there. Should be wrapped up in a little black inaudible.
Inaudible.
I'll do it. Tell me what it is saying.
Welcome, right there. Inaudible, right there, inaudible. Main road,
Already dropped the kids off?
inaudible. Did she have any money yesterday?
Huh?
She didn't have any money on her?
I didn't have time for that.
She didn't have money?
I don't know. Why?
Was asking. I should have went.
I think it...
Man, they're killing their beat, bro.
Why?
They went through his road.
No, he didn't.
Yes, he did. Inaudible.
Who's the driver?
Johnny.
That means he's in there then, right?
Oh shit. That's a Waste Pro truck.
Yeah, put some like Aventura, like Bashada shit like that. Go on. Do you have some Romeo?
Huh?
Romeo Santos?
Santos? What kind of bullshit is that one? Definitely dirty.
That's inaudible dad.
Huh?
His dad.
Where?
In that yellow inaudible GTO.
Ah, my head keeps on hurting.
Inaudible.
Inaudible.
What time is it?
8 something. 8:16.
Let's see what the fuck he said.
Who? You wanted to go. Inaudible, right?
No.
Yawns out loud. Inaudible. You got one more.
Huh?
Inaudible. Up front.
Huh?
Inaudible.
I want to do it when I get out of here.
Inaudible.
Huh?
No man can be happy. Oh, that's all I need.
What?
I'm totally fucked.
Do you have water in there?
Inaudible.
Huh?
Inaudible. Something burnt?
Put something Traviano.
One's life, bro.
I need a fucking drink.
What are you going to do with this?
I have food.
You're gonna eat salad? We're here.
Get me a drink. My fucking mouth is dry.
Huh?
My mouth is dry. Did you hear me? Can you grab me a Monster or a Gatorade?
What?
Hey, inside.
You wanna inaudible?
Huh?
Ain't it?
Huh?
Inaudible.
Who?
You.
An orange one?
Inaudible.
Good.
Now you know how I feel when I get no sleep. I get dehydrated the next day.
It's hot out.
Eat this, inaudible. The dehydrate will go away.
I like when, inaudible.
If you eat this, you get hydrated.
You don't want to eat it? The last one? Fuck you, bro.
Nasty.
Want a sandwich? Hey, want to put your music on? Tastes good, right? Fuck that sandwich up. Rice and beans with ham?
Not yet. Why don't you turn it on? Hey, this bitch is bad enough, inaudible. Lip syncing. Like right there.
There?
Lip syncing. What happened, bro? You're falling asleep.
I'm falling asleep. I'm going to take a 30-minute break. You have to put the one of inaudible Gil. Put on the heavy music.
Lip syncing.
Do you know how I feel now? Like in a beer mode. I'm thinking crazy, I know. I'm going to have to feel as if I'm going out on a bank, bro. I'm inaudible if I have to. Can't do that though, inaudible.
Can't do that too, inaudible. Because I have to be calm like that now. Everything to them. It's fine.
Did she have a purse? Hers? No. If they find her now, they can't do the inaudible final because the mom is not called. She is not missing yet on this side. They don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take her out the sun, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths when I got to her house, and I bathed this morning. I bathed. I cleaned my hands with the cleaner, the one for breaks, because I had gloves and everything just in case.
Did you see the blood?
Huh?
Did you see blood? Did you see?
I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag.
Inaudible.
Exactly. What's for dinner tonight, bro?
Huh?
What's for dinner tonight? I'm thinking pizza. You know I can't go to that street no more.
Which, that one?
By that street.
You're confused with the streets like that.
By there no more with this truck. They can watch me also with that.
This is a work truck, man.
Huh?
This is a work truck. Inaudible.
Right. Did you make the landfill? Inaudible. Everything?
I hope so.
Inaudible. I want to move forward and get out of this mess. You got to run through this side right here. It's bigger, inaudible.
Inaudible.
Hold that. Hold on so I don't lose it.
Lip sync.
I took it off. The one that says Puerto Rico, I took it off. I have to put it back on. Do you smell that burnt shit?
Huh?
Smell it. What is that?
I don't know.
You smell it though, right?
Yeah, keep your eye on it. Can be your battery. Did it start otherwise right? Keep your eye on it. Radio still working?
Yes, sir. Thank you. He waved at us and everything.
He said it audible. Inaudible.
Huh?
Inaudible.
He waved at us. Nice and easy.
All right. What do you feel like cooking tonight?
I don't know.
All right, look.
That's probably what it is.
What?
The batteries. Thank you. Thank you.
Okay, Ms. Rosario, to do one more, isolate that portion.
And if you need to refresh your recollection, the portion that we're going to start on is page 10, line 167 at 5 hours, 59 minutes, and 48 seconds. Are you ready?
I'm sorry, could you repeat the portion, the
So
section?
we're going to go to page 10, line number 167.
Okay.
Ms. Rosario, if you could refresh your recollection and tell the jury what was said at that portion.
Okay. On that side, on that portion, he was saying, no, if they find her now, they can't do then it was inaudible. Final, because the mom has not called, she's not missing yet. On the side, they don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take out the son, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths. When I got to her house and I bathed, this morning I bathed, I cleaned my hands with a cleaner, the one for breaks, because I had gloves and everything just in case. Did you see the blood? Did you see the blood? Did you see? I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag. Exactly. What's for dinner tonight, bro? What's for dinner tonight? I'm thinking pizza. I think that was somebody.
Okay, thank you. And to be very clear, the person who said I had it all over the clothes, but without the evidence, they can't do nothing, was that the individual that was easier to hear?
Yes, that was,
The individual is easier to hear?
yes,
Okay.
MV1, yes.
Okay, all right, thank you. Ms. Rosario, I appreciate your participation. I have no further questions. Defense counsel may have some for you, okay?
Cross-examination.
Thank you, Judge. Ma'am, how many times have you testified in court?
This would be about the 7th time.
7 times.
Yes.
How many times of those were for the defense?
I believe a couple of times,
A couple?
yes.
How many?
2 times.
2 times. Okay. You said that you spent 110 to 150 hours working on what we just heard.
Yes.
How much do you get paid an hour?
$95 an hour.
$95 an hour. Okay. You did a certification for that transcript that you just did, the reading of,
Yes,
is that
yes,
right?
Yes, yes.
Okay, and on your certification, you said pertaining to this case from 8/23/18 is a complete and correct transcript translation from Spanish to English, is that right?
Correct, yes.
Okay, so you certified that this was from 8/23/2018, correct?
Yes.
Okay, no further questions.
Any questions? Further questions from the state?
If you look at your certification, 8/23/18, is that a typographical error?
I don't have the,
I'll show you the certification. Will that refresh your recollection?
yeah, I mean, if that's what I have. Oh. 824, okay, that's a typo.
Okay. Does the video,
It's a typo.
go ahead and read the video, title of the video into evidence into
Yes.
the jury, please.
The title is,
Objection.
I'll sustain the objection. I believe the item that's referred to is not in evidence, so it's asking for the witness to read something that's not in evidence.
Okay. Can you tell the jury this title of the
Objection.
I'm going to show you the electronic copy of the file
Objection,
from
Judge, may we approve?
Exhibit 169.
Let me, wait for a question. Let me see what the question is.
Okay.
The previous objection was sustained because the witness was being asked to say something to the jury regarding something that's not in evidence. If you're using it to refresh her memory, you need to ask a substantive question. You can assist her in answering the substantive question. But you can't ask her a question to read something that's not in evidence. So
Yes, sir.
going forward with that clarification, ask another question.
Yes, sir. If I were to show you an electronic copy of the file that you used in arriving at your conclusions, would that refresh your recollection as to the date of the translation, as to the date of the video that of the recording in this case?
yes, it's 824, there was just a typo where I'm referring to pertaining, but the body of the certification has the correct date,
Okay, so
824.
Okay, tell the jury again, what is the correct date of the video that you translated?
Yes, the correct date for the video is the one I have right on the text.
Stating the objection, you need to answer the question without referring to a document.
Okay, yes, the correct date is 8/24/2018.
Thank you.
Any further cross-examination?
Just briefly, but on the thing that's called a certification, you wrote that the date was 8/23/2018, correct?
That's on the bottom part. On the main text, it has 8/24.
I'm asking on the certification itself, the thing that's called certification. You're looking at it right now. It says 8/23/2018, correct?
That's the second part.
Okay, so we didn't even get that correct, right?
We have, it is correct, and the main, the title that I am certifying
Ma'am,
is
ma'am,
8/24/2018.
permission to approach the witness, Judge?
You may.
I'm talking about the document entitled certification. This is the document.
Correct.
And that where the date is, the certifications is 8/23/2018, correct?
That is not the certification. This is a preliminary certification which was emailed because they were in a hurry
Okay.
to show the judge. This is the final one, and it's got all the information.
Oh, so we got it wrong in the initial one and in that one, correct?
It is not, well, over here on the second part,
It says
it's 8/23, but the text, what I am certifying is correct, August 24, 2018.
Okay, but it says 8/23/2018.
Objection.
At the bottom is a typo.
I'll sustain the objection. I think it's been asked and
certification
answered at this point.
No further questions.
Any further questions from the state?
No, sir, thank you.
May this witness, Ms. Rosario, be released from her subpoena at this time?
Yes, sir.
Any objection to releasing the witness?
No, Your Honor.
You may be released from your subpoena. You're free to stay or leave as you wish. Thank you. You may step down. And the state's next witness or item of evidence.
Yes, so the people of the state of Florida recall Detective Chris Newman.
So if you raise your right hand, please, clerk.
Do you swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
And you may inquire of the witness.
Morning.
Good morning, sir.
Can you state your name for the record and spell your last name?
My name is Christopher Newman. Last name is spelled Newman.
Okay. And during the course of your investigation, did you learn the location of the defendant's residence in August of 2023? Or, I'm
Yes.
sorry, August of 2018?
Yes, sir.
Okay. And what was the location of his residence? What was the street address?
I know it was on Cactus. The exact address escapes me right now.
2613 Southwest Cactus?
Objection.
Okay. Did the defendant live at 2613?
Objection, pleading.
It does not suggest the answer.
I'll overrule the objection. It's an open-ended question.
Did the defendant live at 2613 Southwest Cactus Circle?
Yes, sir.
Okay. And was a search warrant executed on that residence?
Yes, it was.
On what date?
I believe it was August 28th of 2018.
Okay. And did you recover, did anyone from the sheriff's office who executed that search warrant recover any clothes with blood on them?
No, we did not.
Did you recover any weapon with blood on it?
No, sir.
Okay. And, sir, that is all the questions I have. Thank you.
Cross-examination.
No cross.
At this time, may Detective Newman be released, or you wish for him to remain under subpoena?
I wish to ask for a remand.
Please step down, Detective. You do remain under subpoena. And the state's next witness or item of evidence.
Premature approach.
Sure. We're going to take a restroom break at this time for 10 minutes. Please do not discuss the case with each other. Leave your notes in your chairs. We'll be with you in 10 minutes. All right, the jury has exited. Just out of curiosity, before we break, how long do you anticipate the next witness can be?
Less than 30 minutes.
Okay.
Yep.
All right, let's take a restroom break. We'll go off the record.
All right, so what, I'm trying to figure out how do we even tackle this? Okay, so that was Rose Rosario, and then we heard from Detective Chris Newman again. He's the lead detective. No bloody clothes or weapons were found at his residence, meaning Jose's residence. But the recording from the 24th, let's see. I showed my face so they won't assume. Did she have any money? Eric asks. I didn't have any time for that. Did she have a purse? If they find her now, she's not missing. What did she die of? So they will put her in a box and she disappears like that. I already took 2 baths, cleaned myself, cleaned under my nails, and I had blood. Let's see. I had gloves. No one saw the bag. Eric asked, did you see the blood? He said, I had it all over the clothes. Then he says, what's for dinner? I'm thinking pizza. Oof, terrible. All right, so I looked up at Miss Minton, Ashley Minton. She grew up in Fort Pierce, which is where this is happening. She went to University of Florida, which is in Gainesville. Then she moved to San Diego, and she attended the University of San Diego School of Law. There she worked for the Public Defender's Office. After completing law school, receiving her Juris Doctorate, she moved back to Fort Pierce. She married her high school sweetheart. After passing the Florida bar, she accepted a position of the public defender. While at the public defender's office, she's worked. She's also a member of Florida Criminal Defense. She's a member of Mensa. It doesn't say anything about DP. So felonies include. All right. So Ashley and Jeffrey are aggressive. Okay. Who's the other gentleman is Thomas Burns. All right. First degree, second degree, manslaughter, attempted, essay, lewd and lascivious, burglary, trafficking, vehicular, RICO. Doesn't say anything about DP. Family law, personal injury, appeals, criminal defense. I'm not seeing that she's certified for, let me see. Trying to find out. Well, let's look up. I'm not saying that she's certified, but that doesn't mean she's not. I'm just not finding it. Let me see if this guy is. Okay, so Thomas Burns. Nope, that's not him. That's definitely not him. See if I can get a. Nope. Definitely not him. That guy looks like he's in his 40s, and our guy does not look like he's in his 40s. DP certified lawyers are few and far between. Yeah, I'm trying to find. I guess Thomas Burns is a popular name. There's quite a lot of Thomas Burns. All right. Well, whatever. Doesn't matter. You guys talking about yesterday's? Yes, with Sunny Bell. Sentencing is going to be October 27th. Sunny Bell's sentencing is October 27th. Early, too. It's at 8:30. So 8:30 for Sunny Bell's sentencing. Oh, speaking of Sunny Bell, Florida PI Sam. I can now officially announce it. Florida PI Sam was helping to represent Andrew Thompson, and she's going to have a show. Florida PI Sam has a channel, and I'm going to be on bringing all of your questions to her. So she's going to give us an insider's perspective. So if you guys please join us. It's going to be Saturday at 8:15. So Florida PI Sam is going to be. I'm going to be on her show. I don't know if we're co-streaming yet or not. How that's going to work. But we're going to be asking her all the questions that you guys had from Sunny Bell. We're going to be asking her and bring more questions. If you guys have whatever questions you have for Florida PI Sam, she was representing Andrew Thompson, and we're going to be asking her questions that I took notes on. And Florida PI Sam, she is a licensed private investigator. She has her own YouTube channel, and I will drop her link in right now. She was helping to represent Andrew Thompson. So here's Florida PI Sam. So this Saturday, there you go. So that's just her regular channel. So if you guys could go give her some love, go subscribe. She has 1,000 subscribers, so if you can go give her some love now, that would be cool. She's been on. We've done shows before. We did one with Tanika 2 Cents and Joe Schmo. The four of us did a show together. Sam's been on other shows of ours. She was on our anniversary stream. She did, I think, Christmas and New Year's streams with us. We've had her on a few other times too. So. Definitely go give her some love, and we are going to be talking with her about Sunny Bell. So please join us. Good. You guys are subscribing. Florida PI Sam is definitely a friend of our channels. We are a friend of hers. She's been on our show, our channel a couple times. Oh, look at that, 1.05. She's up to 1.06. Very cool. So we are going to be, she'll be streaming 8:15 this Saturday. So I'll tell you guys later today, and then also we'll have a link for you guys tomorrow. So we'll definitely post that for you. But mark your calendars, Saturday at 8:15 in the evening. It's Eastern. We'll be talking with Florida PI Sam about Sunny Bell. So. Good. Thank you guys. Thank you for subscribing. Appreciate it. We got all kinds of people subscribing. All right. Here you go. Subscribe to our friend, Florida PI Sam. She's a Florida licensed private investigator with a law degree and specializes in criminal defense. She was representing Andrew Thompson, who was a Car 3 shooter, and we're going to be talking to her about all of that. So if you guys have any questions about Sunny Bell, we have all kinds of questions lined up for her already. But if you guys want to ask questions live, we will be just asking questions. We're going to hear Sam's perspective, and we're going to be. Hopefully will be answering all of our questions as best as she can. So please join us. So we're definitely having some internet issues today, you guys, some connectivity issues. We're not quite sure what's going on. Sometimes it's really good, sometimes it's really bad. So we know we're having tech issues. So just, it's going to be one of those days, I guess. I don't know. Some days, some moments, we have a really good connection, and maybe they're doing work. I don't know. Something's going on with our internet. So just hang in there. Bear with us. Yeah, thank you, Sparkling Princess. Some days are really good. Some weeks are really good. And then some days it just craps out. I don't know. We're on Comcast, so we've had them over. They've replaced all kinds of lines. It's clear blue skies. You know, I don't know. Sometimes it's just weird. There should be no reason why it's acting up, but also sometimes, like when my computer needs to update, you know, that happened I think last week. So we took care of that. Sometimes it's like, you know, it is our computers. I get that, or our software. Other times it's something else, because right now I can't think of anything that's causing this issue on my end, meaning I've got all my programs off. I've got...
Let's bring in the jury if they're ready.
Before we bring it back, this is the one this is one of the state's exhibits. That's the hard drive. It's
169.
169. We're gonna have it up and open. We're not gonna play from the video. He's gonna play an audio portion, but we're gonna start with this already up, which it's in evidence. They can view it, but I'm just making sure if there's any issues beforehand. I want to...
Which one was the 169? Which translator person?
August 24th with the
With the one that was just testified to. So this is the video and audio portion, and you're just playing overlapping portions.
We're
of
not
what?
even playing it. We're
Okay.
just, we opened it where you can see a pic of inside of the
Picture
truck,
of what
and you
it
can
looks
see
like.
some people, someone
Okay.
driving and someone as a
It's
passenger.
just stills.
This is a video, but it's
Okay.
paused.
Okay.
After they do their identification, we're gonna take it down and then we're gonna play audio.
Yeah. And
Okay.
and then following that, we're going to do the same thing with the exhibit number 170, which was testified to by...
I just want to be sure that what you're playing is what has been testified to.
Yeah.
It has, and we are not playing any portion that we have agreed is redacted.
Okay.
Perfect.
Right.
Yeah. Okay. Very good. Let's bring in the jury. All right, the jury is present, and we proceed with the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida recall Adulfo Cavelli.
Yes, sir.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Yes, sir.
And you may inquire of the witness.
Good morning. Can you state can you state your name for the record and spell both your first and your last name, please?
Yes, sir. Adulfo Cavelli, Adolfo, last name Cavelli, C-O-V as in Victor, E-L-L-I.
Okay. And I believe you testified a few days ago. Were you a senior official at the Waste Pro location here in Fort Pierce in August of 2023? Or, I'm sorry, August of 2018?
Yes, sir.
Okay. And were you familiar with the trash routes of the drivers in August of 2023?
Yes, sir.
Okay. Were you specifically familiar with the trash route of the defendant, Jose Soto-Escalera?
Yes, sir.
Okay. Did he have a trash route in northern Fort Pierce?
Yes, sir.
Okay. Can you tell the jury what his trash route was?
Yeah. I can't give you the exact every road and all that, but it was in North Fort Pierce, in the Andrio Road area, Johnson Road, Rousseau Road, around the Spanish Lakes area, in northern Fort Pierce, St. Lucie County.
Okay. And can you walk the jury through was there a system in place where each of the employees of the Waste Pro, if they were on a garbage truck, what was their knowledge of the camera and recording system?
Yes, sir. So I was there when we had the cameras installed, and every employee that was in the vehicles had to acknowledge that they were being recorded both by audio and visual recordings.
Okay. So did every employee who was assigned to one of those garbage trucks have specific knowledge that they were recorded
Yes.
and that they were videotaped?
Yes.
Okay. And how well did you know the defendant, Jose Soto-Escalera?
He was an acquaintance and an employee, like most of the employees. I was very close with them to get to know their families and ask about them, and Jose was one of those people too.
How long do you think you knew him?
I would say backing up from 2018, a few years. I believe Jose worked for us and then left and came back, but regardless, I've known Jose since his employment at Waste Pro.
Did you have many conversations with him?
Yes.
Did you know him it sounds like you knew him in the context of work, is that correct?
Yes.
Did you also know him socially?
Yes. Yes.
Okay. Do you know him well enough to visualize him, identify him?
Yes.
Okay. We're looking here at a freeze frame of one of the videos from exhibit number 169. If you need to, step down, but do you see Jose Soto-Escalera on the smart TV?
Yes.
Okay. Can you identify him? Which one is he?
The gentleman with the glasses and the steering wheel in front of him to the right of us looking to the right.
Okay. And who is the other individual in the vehicle?
I'd like to come up with that.
Sure. Who is that?
The helper of the route, Eric Alvarado.
Okay. And did you speak to Jose Soto-Escalera enough to recognize his voice?
Yes.
Okay. And based on that familiarity, if I were to play you a clip from an audio of exhibit number 169, would you be able to recognize his voice?
If I hear it, yes.
Okay. Okay, so for the record, we're going to go to page 10, line 167 of the transcript. It will be at 5 hours, 59 minutes, and 48 seconds.
I'll stop it right there. Did you hear two voices in that clip?
Yes,
Was one softer and one more audible?
yes,
Okay. And are you familiar also with Eric Alvarado's voice?
yes.
How long had you known Eric Alvarado for?
Since his time of employment, I don't recall exactly how long. It was a shorter time period than Jose Soto.
Had you had multiple conversations with Eric Alvarado?
Yeah, I'd greet the team every single morning, all the employees, yes.
Okay. And can you tell the jury the identity of the individual whose voice was less audible in that clip?
The one that had a lower voice?
Yeah.
Eric Alvarado.
Okay. And can you tell the jury the identity of the individual who had a more clear and more audible voice?
Yes, that would be Jose Soto-Escalera Soto.
Okay, thank you. I'm now going to show you now we're going to publish States 170, okay? Okay, I'm going to show you a video from August 21st of 2018. Okay, yeah. Okay. Are you, can you take a look at those individuals in that one that's working?
Yes,
Okay. Do you recognize who the driver is?
yes.
What's his name?
Jose Soto-Escalera.
And do you recognize who the passenger is?
Yes,
What's his name?
Eric Alvarado.
Thank you. Yeah. We'll go to August 23rd of 2018. Video. Yeah, and here we are looking at a video from August 23rd of 2018. Who is the driver
Jose Soto-Escalera.
and who is the passenger?
Eric Alvarado.
And here we are looking at August 25th of 2018. Who is the passenger?
With the sunshine, do you mind if I walk up, please?
Sure.
Thank you.
What's the identity of the passenger?
The passenger is Eric Alvarado.
And the driver?
Jose Soto-Escalera.
We'll go to the 27th. Okay, same question on the video from August the 27th of 2018. Who is the driver
Jose Soto-Escalera,
and who is the passenger?
Eric Alvarado.
Okay. If we could return, we're going to do one more. Sir, thank you very much. That's all the questions I have.
Thank you.
Any questions from the defense?
No, Your Honor.
May Mr. Cavelli be released from his subpoena at this time?
Yes, sir, you may.
Thank you, Mr. Cavelli. You're released from your subpoena. You're free to stay or leave as you wish.
Thank you very much, sir.
Thank you. And the state's next witness or item of evidence.
Your Honor, at this time, the people say for arrest.
Ladies and gentlemen of the jury, at this time, the state has rested its case. Let me ask you to step back into the jury room for a moment. Please do not discuss the case and leave your notes on your chairs, and we'll be with you momentarily. All right, the jury has exited the courtroom at this time. The state has rested its case. Any motions from the defense?
No motions from the defense.
Okay, and from the defense, no witnesses other than whether the defendant is going to testify. Do you need time to confer? Sure, confer with the defendant to make a decision whether he wishes to become a witness. I'll inquire of him in that regard, and then we'll go from there. But we'll go off the record, giving the attorneys a chance to speak with the defendant to make that very important decision. Go off the record.
All right, so she's going to talk. She's going to confer with her client to see if he's going to testify. Ooh, you know, I want him to testify. He won't. I don't see him testifying, but I would love for him to testify. No directed verdict yet. No, they haven't done the judgment of acquittal. Maybe that's after she decides if he's going to testify or not. But you're right. Yeah, usually they do. Usually they do the judgment of acquittal. Eric, as far as I know, Nicola is he's in Connecticut on robbery, I think. Is that what I heard? Chat, I think you guys were saying he's 10 years for robbery. We're doing a poll, Gordon. We got a poll going right now. I can only do one poll at once. I got a poll going already. What do you guys think is the most what's the most damaging evidence against Jose? Cell phone data, DNA match to child, Tanya's blood in his truck, or truck video with Eric? I'll let it go. We have 10 minutes, so I'll let it go another 5, and then we'll do another quick poll. Amy Lee, I don't see him testifying either. I hope he does. Oh, he would be perfect for Ego Takes the Stand. Kathy, not with his hot-headed attitude. I know, but that would be great. JMS, directed verdict motion will be denied quickly, of course. They always are. They always are. Definitely a dimmer bulb, Willow says. Sure Life, I think the other attorney said something when she said no motions, he wanted a directed verdict. Oh. As far as I know, what did she say yesterday? She's not going to put on a defense, I think, because they were talking about closings either today, which it seems like they could, or the judge was saying, or Friday morning. So I certainly hope that they get to closings today, because that means they're only going to be, this will get to the jury today. I mean, we could very easily have a verdict. We could very easily have a verdict today if they get to closings and it gets to them by like 3, which is a possibility. All right, so Eric is already in prison. Yes, I knew he was in custody, and I knew it was in Connecticut. But I think, was it Sherry? Somebody, I think it was Sherry or somebody. If it's not Sherry, sorry. If it's Sherry, then woohoo. That 10 years for robbery. So that's what I heard. Oh, have they talked already? Is that it? Have they already talked? Kitty slink by, yes. Oh, I guess they've already talked to him. All right, let's see what.
The defendant regarding his decision to become a witness at this time. Mr. Soto-Escalera, you can be seated, but if you raise your right hand, the clerk will swear you just for a brief inquiry from me on that particular point.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Soto-Escalera, the decision whether to become a witness in the case, unlike most decisions in trial, is personal to you, meaning you receive the advice of counsel, but you make the decision up and above their advice. If there's a disagreement as to whether you should testify, you get to make that call, even if you disagree with your attorney. You have received their counsel. First of all, do you understand the decision is personal to you?
Yes, sir.
Are you deciding to testify or not?
Not, sir.
Not. Are you doing that of your own free will?
Yes, sir.
I will find that you're making the decision not to become a witness freely, knowingly, and voluntarily, and will proceed in that fashion. And therefore, let's discuss the plan. My suggestion is to release the jury till when they come in, have the defense rest, release them till 1 o'clock. We'll do a quick charge conference and give you the remainder of the 2 hours to polish your closing arguments and proceed at 1 o'clock. Is that a good plan?
I think the parties might have agreed a different plan, Judge.
Okay. Well, I'm open. I'm open. I'm just okay. I know we talked about finishing tomorrow too, which is possible. Is that what you had your eyes on?
Yes, sir, if that would be okay with the court. Yeah, Friday works better, if that's okay. We've had a long 3 weeks.
I'm open to that. Of course, the advantage if you do it this afternoon, I realize, I've done your jobs as well, so I realize, what goes into a closing argument. The advantage is, if there is a conviction, you get tomorrow off to prepare. There's that too. But either way, is that what you both agreed on?
Yes, sir.
Okay, that's fine with me. All right, so then I would bring in the jury, have the defense rest, and then tell them they're excused for the rest of the day. We'll do closing arguments tomorrow morning.
I do have a suggestion, Judge.
Sure.
And, you can deny
tomorrow?
it. What?
Rest tomorrow for you?
No. I don't mind resting now. I was just wondering if we could do the charge conference now and charge the jury today, and that way when we come back tomorrow, we could just go straight into closings, and then they deliberate.
You want me to read the instructions to them before your closing arguments?
Yes, sir.
State agree?
Read all the jury instructions before?
Correct, that's
Yes.
the request.
You mean today or tomorrow?
Today.
Today.
That way we make good use of the time.
So then what we would do closing, and then you would remind them and say, I read you the law yesterday?
Yeah, I've never done that, but it's a standard practice with other judges. There's nothing wrong with it.
And they're going to get a copy of it anyways.
Exactly.
Yeah,
I just think that'll give them something to ruminate
Saves us
over
time.
I
tonight.
have no problem. It's time efficient for me.
Right.
And I've always wondered why there's not more requests to do that, because they'll know what the law is before you make your arguments as opposed to the other way around.
Exactly.
Okay. And I'll tell them the attorneys have agreed with this procedure. I'm going to instruct you on the law, and then they're going to make their arguments tomorrow. Don't form any definite or fixed opinion. At this time, you haven't heard their arguments.
Correct.
Are you going to tell them in the instructions about their ability to review the testimony again? I think the only issue was the way it was said could be interpreted that they have to listen to the whole trial, and that that rule only applies to individual witnesses.
Well, let's do the charge conference now.
Yes, sir.
Do you have my latest?
Yes, sir.
You have my latest email in that regard. I just took out, obviously, the defendant has become a witness. What I have remaining for your consideration, from my perspective, before we go back to the beginning, under weighing the evidence, can I take out, has the witness been convicted of a felony?
Yes, sir.
Because there's no such thing in this case. Okay.
Correct.
And how about my default position would be to leave it in, but any pressure or threat been used against the witness that affected the truth of the witness's testimony. We could have had that in this case, but I don't think we is there any of that? Anybody want that?
No, sir.
State?
I couldn't quite hear, I'm sorry.
Has any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Not impressive.
Both sides agree. I'm going to take that out. So now we have in that section 7, with the extras being offered to receive money, which there is, and make an inconsistent statement, which there also is. And all right, so going to the top, any objections to the way I have it? You may, I don't know if you caught this, because the last version I sent you, I don't think I alerted you to this, but there was one section I added in, unborn child, where it should be. I don't know if you caught that, but it's there now, and it's proper in one of the unborn child instructions. I think it was actually on page, what should be page 5 for you, lesser included. That last sentence, the lesser included crimes of first-degree murder of an unborn child or second-degree murder of an unborn child and manslaughter of an unborn child. Before it said just second-degree murder or manslaughter, so I just added that in. It's a very slight tweak. You may, if you see that. But so we have introduction, statements of charges, introduction to homicide, justifiable homicide, excusable homicide, first-degree murder as to count 1, count 2, first-degree murder of an unborn child, lesser included crimes, and then second-degree murder, lesser offense as to count 1, manslaughter as to count 1, second-degree murder of an unborn child as to count 2, manslaughter of an unborn child as to count 2, plea of not guilty, reasonable doubt, weighing the evidence, defendant not testifying, defendant's statements, rules for deliberation, cautionary instruction, verdict, single defendant, multiple counts. As to all of that, any objections or suggestions before I get to the part Mr. Cormier mentioned, which is, I'm going to get to that, what I have now. You can see what I have as far as, it's the second to last paragraph. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know, and we will bring you into the courtroom to do so. That's my standard instruction. I don't touch the issue about rehearing testimony at this time. If they have a note, we do. And what I was alluding to when I spoke to them about that was the default position is to play the entire testimony of those two witnesses, which is the safest, more proper thing to do. I have had it sometimes, and the law does allow, if they specify to us one particular place, you could do that. But in this case, it's going to be extremely difficult. I'm not sure how they would do that unless they were going like section 3 or something like that, as Mr. Richardson was referring to it. You know, if they did that, perhaps there would be an agreement, but otherwise it'd be the default position. And those portions are really not very long anyway, so my default position would be to do that, but it's not addressed in there. So do you want some time to look over what's there and see if you have any objections to it before I actually instruct the jury?
On page 2.
Page 2.
Count 2. In element 2, there's just a typo for the name of the defendant. Actually, and also in element 1.
You're saying page 2. I have page 2 is excusable homicide.
So do I.
Oh no, I'm sorry. I'm sorry. Count 2, first degree murder of an unborn child.
So, yeah, it says
Page 5.
Soto-Escalera.
Oh,
And I think it's spelled wrong
okay,
in the
gotcha.
Yeah, it's spelled wrong in number 1 as well.
It is spelled wrong in the word?
Yes, it's an
E-R-A.
E-R-A.
Oh, okay, gotcha.
And I think in the other count you had his middle name.
Let me see, hold on.
Sometimes it has Tanya's middle name and sometimes it doesn't.
Her middle name or his?
His.
And hers, sometimes she's referred to as Tania Wise, sometimes she's referred to as Tania Esther Wise.
Anyone have a problem if I just get rid of the middle names and we say Jose Soto-Escalera and Tania Wise? Because middle names, like, why are we? It's like a wedding invitation or something, you know.
No objections.
Okay, so I will go ahead and do that. Let me see. Hold on. Let me go ahead and do that. As you're reading over the rest of them, just taking my time and without using controlled find, just going through it, so don't make any other.
We don't have any objections or additions.
They look good? Okay.
Yes, sir.
State's still looking over the instructions, right? Yeah. Okay.
I have no objection to that.
Okay, let me finalize the issue about names.
This should not. The blank.
Right.
Because it never went into evidence. It's just a placeholder.
Yeah, I'm just going to do it like this.
Perfect.
Okay.
Of course, and one of the advantages of doing this too is if there are mistakes that are catch in the instructions, orally I'll correct them, and then of correct them in writing so that they get a perfect copy. It's actually better in that regard. So as I read along, does anyone want a hard copy of the instructions finalized?
I would.
Okay, do that. What I'll do tomorrow too is, it's my normal practice in reading the instructions to explain the verdict form. I won't do that. I'll read them the verdict part, but I'll explain the verdict form to them after your arguments tomorrow before they go back, because it's normally, that's the purpose of that. You're about to go back and deliberate. Also, submitting case to jury, I should probably read that tomorrow. So I'll just stop at single defendant, multiple counts. Tomorrow, I'll reiterate verdict, single defendant, multiple counts, and submitting case to the jury, explain the verdict form, and then send them back tomorrow. But at least I'll get the full instructions on the law at this time.
So I'm wondering if, so they're going to do the jury instructions. So right now they're just kind of going over all the instructions amongst themselves, ironing out whatever it is they need to iron out. And then they're going to read the instructions. It may take, 45 minutes, half hour, 45 minutes maybe? And then they're going to send them home. Yeah, they start reading them even at 12. They'll be done by 1, and then, yep, they're going to go home. Because both state and defense want to do closings tomorrow.
For each side, hard copy. And let's bring out the jury and I'll instruct them. Do ask those who are here in the audience, you're free to remain, but you must remain during the whole instructions. I don't want people coming in and out of the courtroom while I'm instructing the jury on the law. Do doing that tomorrow. Okay. Unless you just want to forego your closing arguments altogether. No?
Not unless you're going to defend me on
Right. I think I'd urge you to do your closing argument. All right, the jury is present. The state has rested its case at this time. Does the defense also rest its case at this time?
The defense rests, Judge.
Ladies and gentlemen of the jury, both sides have now rested their case. What we would normally do at this time is do the closing arguments, and then I would conclude the trial with the jury instructions and have you deliberate. We're going to depart from that and use an alternate procedure, which is perfectly fine and legal and perhaps better for the situation. What I'm going to do at this time is instruct you on the law as agreed upon by the lawyers, and then they're going to make their closing arguments to you tomorrow morning, after which you'll begin to deliberate on the case. The advantage of this is you'll have heard the law already as an advantage to your understanding their arguments to put it into context. But please remember something I instructed you on throughout the trial, which is do not form a definite or fixed opinion on the merits of the case until you've heard all of the evidence, the arguments by the attorneys, and the law as I instruct you. And it was stated in that sequence because that's normally the sequence. So you're going to hear the law, but don't form any definite or fixed opinion until you've heard the attorney's arguments tomorrow. And of course, until the time I send you back into the jury room, don't discuss the case with anyone, including your fellow jurors. I suppose what I'm saying is the fact that I'm going to instruct you on the law now is not an invitation to start your deliberations, which are actually mentioned in the instructions, that you don't start your deliberations until tomorrow after the attorneys make their final arguments to you. Also, I'm going to be reading the instructions to you. Tomorrow, after the arguments are made, these instructions will go back with you into the jury room, and I'll have a copy for each of you individually for you to refer to should you need further reference to the instructions during your deliberations. And members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jose Soto-Escalera, the defendant in this case, has been accused of the following crimes. Count 1, first-degree murder with a weapon. Count 2, first-degree murder of an unborn child. Introduction to homicide. Jose Soto-Escalera is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Tania Wise and her unborn child were killed by Jose Soto-Escalera, you will then consider the circumstances surrounding the killing in deciding if the killings were first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Jose Soto-Escalera may be found guilty of first-degree murder with a weapon, first-degree murder of an unborn child, or any lesser included crime. Count 1, first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tania Wise is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was a premeditated killing of Tania Wise. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Jose Soto-Escalera did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tania Wise. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Jose Soto-Escalera committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of first-degree murder. Count 2, first-degree murder of an unborn child. To prove the crime of first-degree murder of an unborn child, the state must prove the following two elements beyond a reasonable doubt. 1. Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2. Jose Soto-Escalera's killing of Tania Wise was first-degree murder, as I have instructed you in count 1. Unborn child means a member of the species Homo sapiens at any stage of development who is carried in the womb. When there are lesser included crimes, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which Jose Soto-Escalera is accused, there may be evidence that the defendant committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes of first-degree murder with a weapon are second-degree murder and manslaughter. The lesser included crimes of first-degree murder of an unborn child are second-degree murder of an unborn child and manslaughter of an unborn child. Second-degree murder, a lesser included offense as to count 1. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. Tania Wise is dead. 2. The death was caused by the criminal act of Jose Soto-Escalera. And 3. There was an unlawful killing of Tania Wise by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jose Soto-Escalera did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tania Wise. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. If you find that Jose Soto-Escalera committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter, a lesser included offense as to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tania Wise is dead. And 2, Jose Soto-Escalera intentionally committed an act or acts that caused the death of Tania Wise. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Jose Soto-Escalera committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of manslaughter. Second-degree murder of an unborn child, a lesser included offense as to count 2. To prove the crime of second-degree murder of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2, Jose Soto-Escalera's killing of Tania Wise was second-degree murder, as I have instructed you in count 1. Manslaughter of an unborn child, also a lesser included offense as to count 2. To prove the crime of manslaughter of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tania Wise by killing Tania Wise. And 2, Jose Soto-Escalera's killing of Tania Wise was manslaughter, as I have instructed you in count 1. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. it is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. And counsel, I'm striking that next sentence in this particular case. Whatever verdict you render, start over with that sentence. Little tongue twisters here. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proved beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And tomorrow, after the arguments, I will show you the verdict form and explain it to you before I send it back with you for your use. Single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The last instruction is submitting the case to the jury, which I'm going to do with you tomorrow. So after the arguments are concluded, I'm going to reread to you the few of the last pages here before I submit the case to you. That concludes the instructions at this time. Tomorrow we will reconvene at 8:45 in the morning, just as we did today. Remember, I cannot overly emphasize, you have not heard the arguments of the attorneys. Don't form any definite or fixed opinion about the merits of this case at this time. The same rules that govern your conduct remain in effect. Of course, in abundance of caution, please remember, avoid any exposure to any extrajudicial information. Don't talk to anyone. Don't do any research about the case or the people or the issues involved in the case. To be sure, you can find your consideration of this case only to the proper evidence and nothing else. Avoid all of the media coverage of this case. With that, enjoy the rest of your day and your evening, and we'll see you tomorrow morning. Please leave your notes on your chairs. Jury has exited. Before we break, let's take a look at the verdict form as well, just to be sure there's no objections to that. Oh yeah, I wanted to take out the form as to count 2. The state had put in a weapon, which doesn't apply to count 2, so I'm going to take that out. You remember that? Okay. And I also put unborn child in the language as to count 2, which fits the charge. It just said first degree murder. It didn't say unborn child. So I have that as the count 2. And it is still September, so that's correct on the verdict form, right? And so right now the verdict form says what was that? We the jury find Jose Antonio. I'll get rid of the Antonio.
That's all right, yes.
Do that also on the top there. Verdict form. We, the jury, find Jose Soto-Escalera as to count 1, select only one, guilty of first-degree murder as charged in the indictment, guilty of second-degree murder as a lesser-included offense, guilty of manslaughter as a lesser-included offense, or not guilty. If you find the defendant guilty as charged or guilty of any of the above, there's an error there. Above lesser offenses. I'm adding a word there. You must next determine if any of the following has been proved beyond a reasonable doubt. Check yes if proved beyond a reasonable doubt. Check no if not proved beyond a reasonable doubt. During the commission of the offense, the defendant did carry, display, use, threaten to use a weapon, or attempt to use any weapon, yes or no. Count 2, select only one. Guilty of first-degree murder of an unborn child as charged in the indictment. Guilty of second-degree murder of an unborn child, a lesser-included offense. Guilty of manslaughter of an unborn child, a lesser-included offense. Not guilty. So say we all. This blank day of September 2025 for a person. So that looks good. I'll print out a few copies of that to give to you all and for myself here. And anything else before we break from the case? From the state?
My only request for tomorrow would be to have it maybe a 5 or 10 minute bathroom break after the defense finishes their closing.
After the defense part? Well, that reminds me of another issue. So what we should do for the bailiffs, take the lunch order of the jury as soon as possible, because they're going to be here for lunchtime, for sure. Are we still using roots or whatever?
Chick-fil-A, I think.
Oh, there you go. That's less offensive to the jurors than the other miserable food that we were offering them, like some kind of sprouts and something. So that's good. Let's take their order so that it's there and we get the lunch, because it's going to be right about lunchtime that we're going to submit the case to them. And as far as the bathroom break, that's perfectly fine. In fact, Miss Minton, if you want one after they get finished too, just kind of give me a wink and a nod, and we'll do that as well. All right, and if there's nothing else, how about this? Maybe this is a good time to check over the evidence. That be absolutely sure there's nothing going back that shouldn't.
They've already locked it up.
Oh, okay.
Well, I mean, I'm opening it back over, you can look in the box, because the box is really, and it's not gonna take that long. I can pull it out.
There's not that much stuff. It'll
Just to avoid calamity, the items that are not fully admissible, that we've done those. I forget 1/6 exactly,
170, 183.
which are not going back to the jury. But if they did, is there any request for a laptop to go back to view other stuff? There's not, so we're kind of doubly safe. Even if it goes back accidentally, they can't view it anyway because they don't have an electronic.
Well,
no,
I take that back. The defendant's interview.
And the
defendant's
surveillance videos are going back there.
Right, so we need to be
they will have a
extra
laptop.
cautious to make sure that those don't go back. And the other item that's not, just make sure the other items that are not into evidence do not go back into the jury room, because there's several that were marked that are not into evidence, right?
Yeah.
I'm gonna strike that. You all caught that? That was good, Johnny, on the spot. The sentence that I said was, I decide the sentence. Well, no, Judge, why do we spend 2 weeks in death qualification?
We're not supposed to have it in there.
Yeah, right. So that was a good catch by me. I'll strike that and reprint the instructions for myself and for the jury. All right, and then we'll be adjourned until tomorrow morning at 8:45. Thank you.
All right, so that concludes short day. All right, let me just quickly go over the jury instructions. So count 1, first degree for Tania. Count 2 is first degree for the baby, Josiah. Second degree lesser pertaining to count 1. And then manslaughter pertaining to count 1. And then second degree lesser for count 2, manslaughter lesser for count 2. So they do have lessers, but 104 votes. Did the state meet their burden? 95% said yes, guilty. 5% said still not sure. 0% said no, not guilty. What was the most damaging evidence against Jose? 48% of you said the truck video with Eric. 35% said Tanya's blood in his truck. 11% said DNA matched to the child. And 6% said cell phone data. All right, you guys, I'm going to run some errands. I'm going to go to the P.O. box and just going to run some errands. Usually I would do that on a weekend, so woohoo! I'm going to get this done before the weekend. So all that being said, thank you to our mods. Thank you to Aaron. Thank you to chat for being with us. Appreciate you guys joining us today. You heard the judge, 8:45 tomorrow, closing arguments, and then we'll be on verdict watch. And also, Florida PI Sam, we're going to be streaming with her Saturday at 8:15 in the evening. So it'll be, please join us then. If you have any kind of questions about Sunny Bell, we're going to be going over everything about Sunny Bell. So we're going to be talking about the casings. We're going to be talking about the video from the Chevron. We're going to be talking about cell phone data. I was taking a lot of notes and pulling out your comments for her, but now and we'll be going over that. So definitely come prepared with your questions, because this will be your opportunity to ask a courtroom, not only a courtroom insider, but Sam was actually representing Andrew Thompson. So please, please, please join us Saturday at 8:15. We'll post it on our page and everything, and we'll put it out to social media. But please mark your calendars. Saturday at 8:15, Florida PI Sam, Sunny Bell trial. I've never had the opportunity to talk to somebody who's actually been representing one of the defendants. So, absolutely, mark your calendars and go give Sam some love on her channel. All right, you guys. Thank you to our mods. Thank you to Aaron, and thank you, chat. And we will definitely be seeing you guys tomorrow at 8:45 for closing arguments and then verdict watch. So until then, have a great day. And it's early. It's early here. It's only noon here, so I'm going to get some food, and then I'm going to go run my errands. So have a good one. We'll see you guys tomorrow. Bye.